ladies. All you women are smart. And it's so important that you get savvy, just not about your money, but about your financial life. And just so you know, if this is the first time you've been on our webinars, which we've been hosting now for 12 years. We were started by Urban Wealth Management. And again, I'm Rene Nourse, the founder and CEO. This particular topic is so significant because majority of people here in the US do not have an estate planning, more than 50%. And particularly, this is so important for us as women because we live longer. All of us as women know we live longer. And it's so important to not only be concerned about taking care of ourselves, but our family members, the rest of our lives. And these fantastic women who have had their business for over 10 years, they are focused on estate planning services and provide some fantastic services. And we have referred some of our clients over to them to work and provide some appropriate estate planning. And even if you don't have one or you do have trust, it's important to evaluate it and check it periodically, which is something that they are going to cover. So I would like to introduce you to Somita Basu and Zakiya Norton and their firm, Norton Basu, which is perfect, that they are going to give you all the appropriate background and updates that you need to know about how to get savvy about your life. So, thank you. All right, ladies.
Having some technical difficulties here. Okay, everybody, welcome. Thank you for joining us today. I'm Somita Basu.
I'm Zakiya Norton. We are both halves of the firm Norton Basu LLP. We provide estate planning, probate, and trust administration services all throughout California.
So today we're going to be talking about how estate planning is really a women's issue. And we want to talk you through some of the very common misconceptions and really what are the basics of an estate plan, but a little bit about us. We are a minority-owned law firm. We have offices throughout the San Francisco Bay Area and in Southern California. We serve clients throughout the state. And we met while we were volunteering at a legal aid organization in San Jose in October of 2013. So we have known each other for a very long time now. And we are fans of wine tasting. The Warriors may or may not be a thing right now. And of course, Beyonce and all things culinary.
All right, so we're going to start with the 6 myths about estate planning. These are some very common misconceptions that a lot of folks have. So we want to walk you through some of them and talk about why they're incorrect. So myth number 1 is that estate planning is equally important for men and women. While estate planning is important for everyone, it is much more important for women. The reason being that women often inherit twice. So once when their parents pass, and then usually once when their spouse passes, because women live longer. So we have to deal with this issue multiple times throughout our lives. And so it is very important for women to have not only a good understanding of what an estate plan is, but also how it's going to function. You can see some of the statistics here, as to why it's so important for women. We outlive our spouses, typically 5 to 10 years minimum. And so, at that point, these important decisions are left to you. So we're going to cover today a lot about why this is so important for women.
Yeah, the other thing that's important is that so many women are caregivers. So if you are a daughter or a daughter-in-law or a niece, or a granddaughter, and you're caring for somebody who's elderly, it's important to know what's in their estate plan and what can you and what powers do you have or not have, or what things need to be done so you can take care of that person in the most efficient and effective way possible. A lot of women just need to be more aware of those kinds of issues in that role. Okay, myth number 2, everyone knows they need an estate plan, and this is very much not true. It seems obvious, but it's not. 55% of Americans will die without any sort of an estate plan or even a basic will. Even the people who do have a will have not updated it. They might have written it many, many years ago. And, there's a lot of hesitancy to revisit these sorts of issues or even think about it. So that's why we have so many cases that go through probate court, which is what happens when you die with nothing in place or only a will in place. And that is a slow and expensive process. So it's not at all true that everybody knows that they need an estate plan.
All right, myth number 3, and this is really prevalent. Most people think, I don't really have an estate. I don't have anything that I need to plan for. But that's not true. Your estate is comprised of all the things that you own. So you have something. You have an estate, no matter how big or how small. And you've also, got an estate plan. If you haven't made one yourself, the state has made one for you, and it may not be what your wishes are. So it's important to understand that no matter if you've got, a townhouse, a condo, or a mansion, bank accounts, investment accounts, retirement, that's all your estate, life insurance, all of those things. So you've got an estate, most certainly. It's just what level of complexity of planning do you need in your estate plan? That's really the only question we have to answer.
Okay, so myth number 4 is that you only need an estate plan when you're older. And this is something that gets a lot of people in trouble because they wait till it's too late. An estate plan is something that evolves with you as your life and your family and your priorities change. Your estate plan may state certain things when you're single, something different if you get married. It might need to evolve if you have children, and then as your children get older and grow up, it will evolve again. So it's not a one and done kind of plan, and it will evolve with you. Also, you never know what's going to happen. So you need to make sure that you do this when you are younger and make sure that your plan evolves as you age and your priorities change.
Right. I mean, we all hope, right, that we die of old age, but that may or may not be the case for some of us. And additionally, there comes a time where, that window has closed for you to make this estate plan. If you've lost capacity because you've been diagnosed with dementia or Alzheimer's, we've missed the boat. There's no planning that we can do for you at that time because you don't have the capacity to do it any longer. And, we talk to a lot of families who are in that position and asking, what can we do? How can we plan? How can we make sure that we avoid probate for mom? And unfortunately, we say there's not anything that we can do now. So the time to do this is when, you've got all of your faculties, right? You can think through these decisions, and you can make the plan. So it's in place before the crisis happens. All right, myth number 5, a will and trust are essentially the same. They're the same in that they carry your wishes for what you would like to happen, right? How you would like your things to go to your loved ones. So they're the same in that regard, but there's a huge difference between a will and a trust. And that is that in the state of California, if all you have is a will, then you are guaranteed that your family and your estate are going to have to go through the probate process. So it will tell the court your wishes and how you would like things to go, and the court will look at that and follow those. However, we're still dealing with the court process. A trust is a way to get around the probate process in California. Same idea, you get to name, your beneficiaries and think through how you want things to go to them, but your family gets to avoid going through the probate process.
Okay, myth number 6, I can do my own trust online. We hear this a lot. Online estate planning software is usually going to be something that is not going to fit your needs if you have any sort of substantial assets, which in the state of California includes just owning your home that you live in. We have actually tested some of these online software platforms and found a lot of drafting gaps and things that we would not do, and really potentially errors. And the problem with doing an estate plan online is that you won't know what's wrong with it after you create it, but your children will once you're gone. And now there's a lot of ambiguity or there's errors, and now they have to go to court to clarify or get instructions or figure out what you really meant or what they're legally able to do. So it's really not worth it in the long run for the money that you think you're saving.
Yeah. And I mean, really, you don't know what you don't know, right? So you're not going to be able to identify, right, if there's something wrong with the boilerplate, maybe there's been a change in the law, or maybe your circumstances really don't fit inside some of these cookie cutter options. And as Somita said, you're not going to know that. Your family is going to figure that out after the fact. And then they're going to have to hire an attorney to see if there's any opportunity to make changes, right? And sometimes you can, and sometimes you really can't. And the other thing I would say is, trying to do this online is kind of like Googling your symptoms on WebMD, right? It's not going to lead to anything good. And it's not going to be accurate as to what pertains to your particular situation.
Yeah, I can attest to the fact that WebMD is not at all a good place to go with symptoms. So
No.
you definitely don't want that. Okay, so those are some of the myths about estate planning. So now we're going to talk about, okay, I'm convinced that I need an estate plan. Now what do I do? What is an estate plan? So there's really only 7 steps to get to a complete estate plan, and we're going to walk you through what those are.
All right. So the first step is, what do I have? What makes up my estate? And so we've got some things here listed for you to start kind of thinking about what kind of things should I be contemplating that are going to be going into my estate plan. And so, cars, obviously your primary residence, any rental properties you have, that timeshare that you got talked into buying in Hawaii, that's going to go in your estate plan as well. Your bank accounts, your investment accounts, any businesses. And this is California, and certainly up here, I know in the Bay Area, everyone's got an LLC or an S Corp. So that's got to be speaking directly with your estate plan. And then, of course, any valuable or even just sentimental items. A lot of families have items like this. In my family, it's a cookbook that's been passed down generation after generation. And my mom had to put it in her estate plan because we would have thought about it. So it can come all the way down to those kinds of things. The idea is you think through all these different items and assets, and you decide, how do I want this to go so that your family doesn't have to figure that out later.
Yeah, in my family, it's my mom's wedding jewelry. I've told her that I specifically want it and not to give it to my sibling. And so it's good to have those discussions because you would be surprised at how much conflict there can be over the sentimental items. It can get really, really heated. So it's important to address all of them.
Yeah, I would say that's actually a lot of the conflict that we see in families is typically over sentimental items and not high value items. So, don't overlook those things when you're thinking about your estate plan.
Absolutely. Okay, so step 2 is to establish a living trust. And we're going to talk about what a living trust actually is, but a living trust is an agreement that you enter into with yourself to set up an entity, which is a living trust. Now, the living trust will actually include all of the things that most people think go into their will. When you think of on TV and movies, and there's the reading of the will of who gets what and under what conditions, all of that goes into your living trust. And your living trust will control who gets what and when. It will also talk about, who do you want to manage money for your children if you were to pass away before they reach the age of majority? Do you want them to have everything when they turn 18 if you're not around? Usually that's a pretty bad idea, right? So you can actually stagger out payments and put conditions for distribution in your trust. And it's a lot easier for somebody to manage than if you had to go to court and manage all of those things.
All right, so we've been talking about this idea of a living trust, and a good way to think about what a trust actually is at its essence is just a gift box. You're placing, your assets inside of that gift box during your lifetime, and you're deciding who's going to get them and how. And once you pass, then the top of the gift box is closed, nothing else can go in, and the bottom is now going to open. And those items, assets, those things are going to flow out to your loved ones according to your wishes that you've laid out clearly in your living trust. Another thing to note is that living trust can go by a couple different terms. So some people call it living trust, some say a revocable living trust, a revocable trust. Those are all the same thing. The idea is, revocable living, meaning you get to change it throughout your lifetime as long as you have capacity to do so. So this is a living, breathing document. And as your circumstances or wishes change, then your document should change right along with it.
Yeah, and the other thing people seem to be worried about is tax consequences. So the thing to note is that a living trust does not impact your income tax. It doesn't give you a benefit, but nor does it harm you. So it's income tax neutral. And it also does not affect your property taxes during your life. You can always transfer your property into your living trust without any change to your property tax base. And that is the law in the state of California. So they are encouraging people to do this by having that exemption for the property tax. And so that is something that I know a lot of people are worried about, but it does not have an impact on property tax or income tax. Okay, so then now you've created this gift box, you have to put something in it. Okay, and so in order to do that, we call that funding your trust. And that simply means that you are changing the title on the deed to your home, on your bank accounts, on your investment accounts. You're changing the title. So instead of Beyonce and Sean Carter on your deed, it will say Beyonce and Sean Carter as trustees of the Carter Family Trust. So you've now changed the title so that the property is now considered to be a part of your trust. So you've effectively opened the top of that gift box, put that house in it, right? Or that bank account, or that investment account, or the timeshare if you have one. But the top of the box is still open. So you can still sell it. You can refinance it. You can buy another property and put something else in there if you wish. So the top remains open, but these things are now in the box.
And this is really the most important step. I would argue once your estate plan is done, once you've thought through these things, is making sure that all of these different assets actually get titled in the name of your trust. That's a step that some folks can miss. And then, your family may ultimately end up back in probate again, right? Because we haven't finished this process. So one particular thing to note is that if you've set up your trust, you've done everything right, you've put the home in the name of your trust, and down the road you decide to refinance, the banks will help you get the title out of the name of your trust and into your individual name so they can secure that loan, but they may or may not help you put it back into your trust. So whenever you're doing those kinds of things, make sure you're reaching out to your attorney so that they can stay on top of making sure that that home or whatever asset gets back into the name of your trust.
These seem like very nitpicky little things, and maybe, you're kind of tired at the end of the estate planning process and you don't really want to go through and do all this type of paperwork, but it's really, really important, and it makes a huge impact if something were to happen to you and your assets are not in your trust. So it's very important to make sure you follow through, or that your attorney is helping you follow through.
All right, the last piece with the will, I will say, that works in conjunction with your trust is that it's going to be a particular type of will. So this is going to be called a pour over will. So it's not going to be like what Somita described earlier of, you know, reading the last will and testament like you might see on TV or the movies. By the way, that does not happen. But it's going to be different in a couple of ways from a traditional will. So first, it's going to have that pour over language, which essentially is just language that's gifting your assets to your trust. So now we're again talking about this idea of, uh-oh, what if some asset wasn't titled in the name of my trust? That language in your will allows attorneys to use a very specific kind of petition and ask the court to put those assets into your trust. So it's kind of like a backup, you know, catch-all safety net. And so it's really important that you have that kind of language in your will if you have a revocable living trust. The other thing that's going to be different about your pour over will is that it shouldn't have any information about your assets or your beneficiaries. And that's because wills are public documents. So when we die, they get lodged with the court for safekeeping, meaning somebody can't get in there with a Sharpie and start writing other things, right? And gift themselves your house. But it's public, meaning anyone can go take a look. And we know that, right? Because we have way too much information about Prince and Aretha Franklin with wills and couches and all kinds of things, right? We know all of their business because wills are public documents. So again, you know, your will should be private. It shouldn't have any of that information in there to protect your beneficiaries. And it will go through probate unless you have a revocable living trust.
And just a side note about probate, probate is basically a court process whereby the will is presented to the court. Whoever you name as your executor, a will has an executor, applies to the court to be granted powers to do what the will says you wanted, what you said in the will that you wanted to happen. And in order to get all of those powers and go through the entire process of gathering all the assets, paying the debts, notifying creditors, all of that takes anywhere from 12 to 24 months in a relatively straightforward case. If anybody is fighting or is uncooperative, any of the beneficiaries, then you're looking at longer than 24 months. So it's really important to note that a will does not avoid the probate process, but a living trust does. All right, step 5 is to create a power of attorney. So a power of attorney takes effect while you are alive, but incapacitated. And that means that the incapacity can be something short-term, like, hey, you're in a car accident and you're in the hospital for 3 weeks or a month or longer, or you've been, you know, you're on a ventilator for a month and you can't communicate, or it could be something more long-term, like some sort of a neurological diagnosis like dementia or Alzheimer's. And what the power of attorney does is it gives your agents, the people that you name, the ability to manage your financial affairs. They can conduct financial transactions, pay your bills, open new accounts. They can even change beneficiary designations, but they cannot update your will or trust. So whatever you've written will stay the way that it is. You cannot use a power of attorney to do those things unless that's a power that's specifically granted, and that's very uncommon.
All right. Along with the power of attorney, another document that works in case of incapacity is your advanced healthcare directive. So now, of course, we're not talking about financial matters. We're talking about healthcare decisions. So who is going to step in and advocate for you if you're unable to do so, and who is going to make those important decisions about what kind of care you want, or sometimes more importantly, what kind of care you don't want in certain situations. And so when you think about who to name, there are a few things to keep in mind. I would say one is make sure you're picking somebody who is going to actually follow your wishes, even if they are different than what that person might choose for themselves. They need to follow whatever you've decided in this document. Two, it's a really good idea to pick somebody who's local. A lot of our clients pick folks who for some of these other roles that are not here, and that's fine. But for this, we're usually dealing with some sort of emergent, crisis of some kind. So you want to make sure that you have somebody who's able to actually make it to whatever hospital you're at and deal with the healthcare providers. So naming somebody, across the country or out of the country is probably not a good idea. And last, it's a really good idea to pick a backup. If for some reason the first person that you've named is unable to step up for you for whatever reason, hopefully you've named an alternate who can step in and make those decisions for you.
And those are the 6. Actually, there's actually only 6. Step 7 is to celebrate. You're done. Those are the key documents that you need. They work hand in hand. They work together to take care of you if something happens to you while you're alive, or to take care of your loved ones if you happen to pass away. We are Norton Basu. We are the partners here. We're the founding members, and we serve clients throughout the state of California. We have offices in Los Gatos, Santa Clara, and Oakland in the Bay Area, and in Los Angeles in Southern California. And we're always here to answer questions and to help.
Yay! And there will probably be a lot of questions that will come up. This was fantastic to be able to share all of these phenomenal things that you all covered. And I think that, I hope, not think, I bet everybody has taken notes because they need to know all of these important elements. That is key. So what I would suggest is that we definitely will want to make sure that we all stay in touch often, and that there should be a very, very important point that everybody needs to know and has learned again and again. And I have always said, for example, too, it's so important that we all just not have a will. And to your point, because I've had this happen with a few people, that if they had a will, there were some scenarios where people, and I did have a couple of clients, this was years ago, where somebody showed up at their house, somebody had a will saying, oh, you didn't know I'm your sister, you didn't know I'm your brother, because they were able to go into that state, that city, because wills are available for people to see and know when somebody has passed away. And that's why it's so important to have a trust, because you've got privacy. Nobody will know that. So thank you so much for this significant, apparently so significant. So smart women, you can continue to get savvy about your financial life. And this is one of the things that's at the top of the list that you need to be aware of, that you need to do, and to get that taken care of as soon as possible. You have access to reaching out to Norton Basu, and they will provide you with not only setting it up, but also reviewing what you currently have. So thank you all so much for your time and your expertise.
Thank you for having us.
Absolutely.